This short video is for Paper 2, US and Comparative Politics, the Constitution, and this video is going to be about how the US Constitution can be amended. In Paper 1, you will have learnt that the UK Constitution is uncodified and therefore there is no formal process for amending the United Kingdom Constitution. So things like voting rights and marriage rights have changed through simple acts of Parliament. The huge constitutional change of leaving the European Union began with a referendum, but also later on involved the executive, the judiciary and the legislature after that referendum. And so in the United Kingdom, there's no formal process. Nowhere is it written down what is expected. The idea that a referendum would be held on matters of constitutional change is a convention in British politics, and even then it's a fairly recent one. Whereas in the US Constitution, it lays out specifically how the Constitution can be amended. Now, the Constitution has only been amended 27 times. 17 of those come after the Bill of Rights. And so we could look at that two ways. Either, number one, the Constitution is sufficiently both vague enough and protective of the rights of citizens and effective enough that it has worked in the long term. Or we could say that the fact that this has only been amended 27 times, and the first 10 of those were the Bill of Rights, those limited number of amendments might actually mean that it's too difficult to amend the Constitution. So the first way and the most obvious way is when both houses of Congress, by a 2/3 supermajority vote, approve an amendment to the Constitution. And then 3/4 of state legislatures ratify that amendment. So on the first graphic, it's on the left, and on the second graphic, it's the row along the top. A vote by 2/3 of both the House and the Senate, followed by 3/4 of states approving the amendment, gives us an amendment to the Constitution. All but one constitutional amendment has followed that process. The only time where a different process has been followed is the 21st Amendment, which was repealing prohibition, whereby we did have the 2/3 of both houses of Congress vote to change the Constitution. However, rather than state legislatures, in the case of the 21st Amendment, special state conventions were held to pass this change. It was the same vote percentage needed, 3/4, but in the case of repealing the 18th Amendment, repealing prohibition, special state conventions were called. Over 3/4 of them voted in to change the Constitution once more and legalise again the manufacture and sale of alcohol. The proposal that hasn't been used is there has never been an amendment that has been brought about after there's been a convention called by the states. That has never happened in American history. Two things to note before we move on, and I've highlighted them on the left. On all but two occasions since 1917, Congress limits the amount of time that states have in order to ratify an amendment. And later on in this video, there'll be a discussion of the Equal Rights Amendment, which is one of those amendments that ran out of time. But there's also an additional complication to that, because some states have gone back on their initial decision to vote in favour of the amendment, and whether states are allowed to do that doesn't have constitutional precedence, so we don't know whether a state has the right to do that or not. It also says underneath there that 33 amendments have been passed by both houses. Of those 33 that have gone to the states, 27 were ratified, which leaves us with only 6 that have passed through Congress and not made it past 3/4 of states. And as I said just then, one of those is the Equal Rights Amendment, originally passed in the 1970s, which we'll talk about more in this video later. So I think it's wise that we split constitutional amendments up between the first 10, which are collectively known as the Bill of Rights, and the following amendments that were made after that. The Bill of Rights were sort of passed in one fell swoop, proposed in 1789, and became approved and active amendments to the Constitution from 1791. Some of them have been absolutely crucial in the lives of Americans, others less relevant today than they once were. So, for example, there is a lot more focus and debate on the Second Amendment than there is the Third, and we'll talk about the reasons for that in just a moment. So the First Amendment is quite significant because it is covering an umbrella of rights in one fell swoop. The First Amendment gives Americans the right to the freedoms of religion, speech, assembly, and petition the government, which is essentially the right to peaceful and legal protest. So we've got some key rights dedicated to American citizens in the First Amendment. The Second Amendment, which you will have no doubt come across before and spoken about in class already, is the right to keep and bear arms, because a well-regulated militia is necessary to the security of a free state. And the debate over the Second Amendment is its vague wording. The idea that is it that every individual American has the right to keep and bear arms, as the second sort of half of the amendment states, or were the Founding Fathers thinking about the first half of that amendment, which is that a well-regulated militia is necessary to the safety and security of a state? The Third Amendment is very much of its time. The Third Amendment essentially said that the government or any other body cannot force a citizen to house a soldier, and that is something that the British regime had done during and prior to the American Revolution. So the Third Amendment, less relevant today. The Fourth Amendment, unreasonable search and seizure, so you've got to have good reason to stop somebody, search them and their property and seize their property, and also we get warrants can only be issued on the basis of probable cause. So later on in the 20th century, we're going to get debates over Miranda rights, and you will have seen in television shows when somebody's arrested, you have the right to remain silent. If you cannot afford an attorney, one will be provided for you, etc., etc. That sort of has its origins in the Fourth Amendment. This idea of warrants issued on the basis of probable cause. You cannot simply search an individual's house because you think they're up to no good. And so it's, again, aiming to limit the power of the state and the arm of the state in the form of bodies like a police force from unreasonably impacting the freedoms of citizens. Now, the Fifth Amendment provides people with a few rights, particularly to do with the criminal courts. So we get this... You cannot be held and sentenced for a serious crime without first had a trial by jury. It also denied double jeopardy, which is essentially once somebody has been tried and found not guilty of a particular crime, they cannot simply be tried again for that crime. You cannot bring someone back in front of the courts because you didn't get the decision the first time around that you were hoping for. But then we also get the right to avoid self-incrimination. And quite often you will hear again in television shows, people talk about pleading the Fifth. And essentially when you plead the Fifth, when you invoke your rights according to the Fifth Amendment, you are providing yourself with the protection of freedom from self-incrimination. And that cannot be taken as an admission of guilt. So if somebody was to say, I invoke my Fifth Amendment rights, which is I'm not going to say anything which might be used against me at a later date, that should not be taken as an assumption that this person is guilty of a crime simply because they're not providing the answers in a trial or police interview that you want them to provide. In a criminal case, the burden is on the state to prove that the crime has been committed, not on the suspected individual to prove their innocence. So the freedom of the Fifth is you should not be expected to self-incriminate. You shouldn't be expected to provide evidence if it's going to be used at a later date. Your own words are going to be used against you at a later date to sentence you for a crime. So, the Sixth Amendment, a speedy and public trial by an impartial jury, and the right to assistance of counsel, so legal counsel provided for all if they are unable to provide their own. The Seventh Amendment, right to a trial by jury. So the 5th, 6th and 7th is very much the rights of individuals suspected of committing crimes. The 8th Amendment, again, similar sort of arena. Excessive bail shall not be requested. So bail should be, in theory, proportional to the crime that has been committed, but also that it's affordable for an individual and it's not set at an unreasonably high amount to deny somebody the right to be bailed. But it also talks about cruel and unusual punishment. And that is the amendment that has led to lots of challenges to the ways in which the death penalty has been enacted in the United States. So you may know that in years gone by, some states authorised use of the electric chair, which has since been judged in the Supreme Court to be a cruel and unusual punishment. And so that is no longer legal in the United States. And then the 9th and 10th Amendment essentially says, in the 9th Amendment basically says, anything that we haven't mentioned here does not mean that that is the only rights that American citizens have. So the 9th Amendment is essentially saying this is not an exhaustive list. This does not mean that Americans do not have any rights beyond this. And that gives government the flexibility to improve and enact individuals' rights later on. And then the 10th Amendment is essentially saying that in this document, any power that is not expressly given to the federal government, then the authority is down to the state government. Any powers of government not delegated belong to the states. So that is why we get the Dobbs decision in 2022 in the Supreme Court. This is why people are wrong when they say that abortion is illegal in the United States. All the Supreme Court said in the Dobbs versus Jackson decision is that the issue of abortion is not sufficiently covered in the original document of the US Constitution, and therefore, according to the 10th Amendment, it is the state's decision. So how far women have autonomy over their bodies, how much choice a woman has when it comes to regarding an abortion, is not covered by the main document of the Constitution, and therefore is a states' rights matter. Now we come on to the subsequent amendments after the Bill of Rights, and all but the 21st Amendment, which repealed the 18th Amendment, followed that process of a 2/3 vote in the House and the Senate, followed by a 3/4 vote in state legislatures. The only time we have seen these special state conventions is in the case of the 21st Amendment. The 13th, 14th and 15th Amendment, I'm going to talk about those collectively. They're known as the so-called Reconstruction Amendments. They were passed in the immediate aftermath of the American Civil War. So what the 13th Amendment did is it enshrined in the Constitution something that had been government policy during the Civil War in the form of the Emancipation Proclamation. Now, the problem with the Emancipation Proclamation was, well, there were two. Number one, it only applied to the Confederacy because it talked about rebel territories. So the Emancipation Proclamation outlawed slavery, referred to the enslaved as henceforth free, and granted them their liberty. But if you were enslaved in a Union state, and the border states did have slavery during the Civil War, you were still enslaved. So that was one problem. Not all the enslaved were freed by the Emancipation Proclamation. The second problem is, as a proclamation by the government, it can be quite easily overturned. And so the passage of the 13th Amendment enshrined the end of slavery in law. Now, it was particularly useful for that to happen for the Lincoln government when many of the Southern Democrats who had previously been in Congress and had left when the Confederacy was formed, it was easier to get these amendments passed. So the 13th Amendment essentially expands and enshrines the Emancipation Proclamation and ends slavery in the United States. The 14th Amendment was important at the time and is still important through the years. And it's because there is a very important clause in the 14th Amendment, the Equal Protection Clause, which has been used time and time again in the Supreme Court to discuss to debate and to decide whether or not American citizens are given equal protection under the law. So, Brown versus the Board of Education, the decision to end segregation in the South, judged that there was not equal protection under the law if segregation was in place. Roe versus Wade, did all American citizens have equal protection under the law depending on which state they lived in? And so the 14th Amendment and the Equal Protection Clause was important then, but was also very important in the forthcoming decades. And then finally, the 15th Amendment enshrined voting rights and said that they could not be denied based on race, colour or former status as a slave. We might need to fast forward now to the 26th Amendment, but also the 19th Amendment, because voting rights are enshrined based on racial grounds, but they're not enshrined for women. Now, many states had votes for women from the outset. The suffragist and suffragette movement in America was not as intense in the United States as it was in the United Kingdom. I don't think women were as oppressed in the United States when it came to voting rights. However, the 19th Amendment prohibited any state from denying women equal rights to vote simply based on their sex. And then the 26th Amendment lowered the voting age to 18. Two more that I want to talk about. The 17th Amendment established direct election of US senators. Remember that in the early years of the experience of American government, the Senate was supposed to be appointed by state legislatures. It was the idea of the Founding Fathers that the Senate would be the less populist house of the two, that the House would represent populist thought, mass democracy. The Senate would be there to provide a break on populism, so that change was not as radical as the people may want it to be. But the 17th Amendment provides a change to the Constitution and directly elected senators. Then finally, the last one I want to talk about is the 24th Amendment, which prohibited any poll tax, any requirement of payment as a qualification for voting. So, now I want to use a case study to talk about why it can be so difficult to amend the United States Constitution. And what we're going to do is we're going to look at the Equal Rights Amendment. Now, it was first proposed in the 1920s, at the same time that women's right to vote was enshrined in the Constitution. And the wording of the full amendment is there. So the Equal Rights Amendment, equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. So what we have is essentially the spirit of voting rights for women applied to all law, essentially outlawing sex discrimination. Now, it was introduced to Congress in 1923, but it does not pass through the Senate until 1972. So the amendment took nearly 50 years just to get through the House and the Senate. Once it gets through the Senate in 1972, it goes to the states. However, Congress had set a deadline on ratification. Originally, that was supposed to be in 1979. And so an amendment that took 50 years to get itself through Congress now had just 7 years to be passed by 3/4 of US states. It seemed like it wasn't going to be a problem because by 1977, 35 out of the 38 states needed had approved the amendment. Just 3 more states were needed. Then the debate really heated up. There was a pro-equal rights amendment and a stop ERA movement, both of which were campaigning fiercely. And so, in 1978, an act of Congress signed by then-President Jimmy Carter extended the deadline to the 1980s. However, no additional legislatures added their names to the 35 that had already approved it by the time that deadline had passed. But it doesn't stop there. There are 3 states in recent years that have passed the Equal Rights Amendment, and at the moment it is just a symbolic passage. But in the wave of a new feminist movement that sprang up in the 2010s as part of the wider Me Too movement, the states of Nevada, and Illinois and Virginia all passed the Equal Rights Amendment, which means that after the deadline, the Equal Rights Amendment has the necessary 38. But not really, because 5 states, Idaho, Kentucky, Nebraska, Tennessee, and South Dakota, have since voted to revoke their ratifications of the amendment. 4 of them were before the first deadline. And so we're in a really confusing situation whereby the ERA has the 38 votes after the deadline, but might only have 33 votes again. And that, sorry, I say again, it's back down to 33 votes. Now, whether that is possible is uncertain, because the Constitution doesn't say whether a state legislature or Congress, in fact, are able to revoke their passage or ratification. There is nothing laid out in the Constitution that says that those 5 states have the right to revoke ratification. Regardless, both based on the 1979 and the 1982 deadline, those 38 states were never, those numbers were never collected in time. And when we did get to the number 30, to those 38 states in the 2010s, a whole 90 years after this was first proposed to Congress, even once we'd got to that number 38, there's the constitutional matter and the controversy of 5 states revoking ratification. The second case study I want to talk about is flag desecration. This is one that has been in Congress many times before, but has, again, never been formally an amendment to the Constitution. So in 1989, there was a Supreme Court case, Texas versus Johnson, and the Supreme Court ruled in favour of Johnson and argued, or they decided, rather than argued, they decided that burning the American flag is a constitutionally protected form of free speech. And so, because of that decision, there then grew a movement to amend the Constitution so that right was taken away from American citizens. So for those politicians that disagreed with the Supreme Court's decision, they sought to amend the Constitution to outlaw desecrating the American flag. Because in 1990, Congress had passed the Flag Protection Act, and that law basically said if you mutilate or defile or burn or trample upon the US flag, you're committing a crime. The Supreme Court ruled in US versus Eichmann that the Flag Protection Act was violating the free speech rights of American citizens. So, in 1995, the House passes a constitutional flag amendment, 312 votes to 120. However, in the Senate, that 2/3 majority wasn't guaranteed. It was 4 votes shy of the 2/3 majority needed. It was only 63 votes to 36. And in the Senate, those who supported the amendment needed 67 votes. So it was 4 votes shy in the Senate. It passed one house, but not the other. The House tried again in 1997 and succeeded in passing a constitutional amendment based on flag desecration. It safely got that 2/3 majority. However, in 1998, it died in the Senate once more. 1999, the House passes it again, 15 votes above the 2/3 majority needed. But again in the year 2000, 4 votes short, the amendment falls short in the Senate. So what we can see is we have 3 occasions between 1995 and the year 2000, on 3 occasions, this proposed amendment passed through the House but didn't get through the Senate. So this is an amendment that has passed through the House many times and never through the Senate. Now, for most Republicans, they tend to support this Desecration Act. And that image there that you can see is what Republicans and supporters of the amendment are most concerned about when the American flag is burned or desecrated, stamped on and defiled in an aggressive or political manner. But there would be all sorts of constitutional debates to be had. What if it was the 4th of July and there was an American flag tablecloth, an American flag napkins, and an American flag plates? If you are eating off the American flag, is that desecration? So there are many people that think that this issue is more nuanced than you would first think. And so that is one of the reasons why this amendment has never passed. And it is still an issue that goes on today. There is a Republican in the Senate for Montana, Steve Daines. He has proposed this amendment in both 2019 and 2021, and we haven't had the sufficient progress that Daines would have liked. The American public tend to support this amendment. In 1999, it was 63%. By 2006, it was down to 56%. In 2020, only 49% of people thought that it should be illegal to burn the flag. So the numbers of people supporting the amendment is slowly dropping, but it is still higher than those that think that burning the flag should be legal. So in 2020, 49% of Americans felt that it should be illegal to intentionally desecrate the flag. 34% said it should be legal and that it is an American's freedom of speech, and the rest weren't sure on the matter.